Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Mackenzie Willis and People v. Edward Martinez-Fernandez decided on March 13, 2025. Troutman, J. These appeals implicate the standard for determining the facial sufficiency of misdemeanor complaints. Common to both appeals are defendants' contentions that the complaints upon which they agreed to be prosecuted were facially insufficient for failing to assert evidence of a factual nature demonstrating reasonable cause to believe that defendants knew or had reason to know they were driving with suspended licenses in violation of Vehicle and Traffic Law Section 511, 1A, aggravated unlicensed operation of a motor vehicle in the third degree. We conclude that the appellate term properly affirmed defendants' convictions because the misdemeanor complaints were facially sufficient. 1. People v. Willis. A police officer spotted Mackenzie Willis driving in Lower Manhattan in October 2018. The officer's search of the electronic records of the Department of Motor Vehicles, DMV, revealed that Willis's license was suspended at least 3 times for failing to answer traffic summonses. After stopping Willis's vehicle, the officer arrested Willis and charged him by misdemeanor complaint with 1 count each of aggravated unlicensed operation of a motor vehicle in the second and third degree. People v. Martinez-Fernandez. Defendant Edward Martinez-Fernandez, a taxi driver, was arrested after a traffic accident in the Bronx in July 2016. A police officer's search of Martinez-Fernandez's DMV records revealed that his license was suspended at least 3 times for failing to answer traffic summonses. Martinez-Fernandez was charged by misdemeanor complaint with reckless driving, Vehicle and Traffic Law Section 1212, aggravated unlicensed operation of a motor vehicle in the second degree, aggravated unlicensed operation of a motor vehicle in the third degree, and unlicensed operation of a motor vehicle. 2. It is undisputed that defendants Willis and Martinez-Fernandez each waived prosecution by information, pleaded guilty to third-degree aggravated unlicensed driving in satisfaction of all charges, and were sentenced to a $200 fine and an $88 surcharge. In each case, the accusatory portions of the complaints alleged, among other things, that defendants were operating their motor vehicles while knowing or having reason to know that their licenses were suspended. The factual sections of each misdemeanor complaint contained averments that an officer, I, saw the defendant operating a motor vehicle. 2. Conducted a computer check of the DMV's records and determined that the defendant's license was suspended 3 or more times on at least 3 different dates for failing to answer, appear, or pay a fine pursuant to Vehicle and Traffic Law Sections 226, 3, or 510, 4A, 3, knew that the defendant knew or had reason to know his license was suspended because traffic summonses have printed on them. If you do not answer this ticket by mail within 15 days, your license will be suspended, and 4, understood that the suspension occurs automatically, by computer, within 4 weeks of a defendant's failure to answer. The complaints were further supported by DMV abstracts memorializing defendants' license suspensions. Both defendants appealed to the appellate term contending that the misdemeanor complaints should be dismissed as facially insufficient because they failed to provide reasonable cause to believe that defendants knew, or had reason to know, their licenses were suspended. 2 unanimous panels of the appellate term affirmed. Both panels concluded that the misdemeanor complaints were jurisdictionally valid because they described facts of an evidentiary nature establishing reasonable cause to believe that defendant was guilty of aggravated unlicensed driving in the third degree. People v. Willis, People v. Martinez-Fernandez. Specifically, the appellate term found that the factual allegations in the complaints, including the DMV abstracts, were sufficient for pleading purposes to establish reasonable cause to believe that defendants knew, or had reason to know, that their licenses were suspended. A judge of this court granted leave to appeal in each case. See People v. Willis, People v. Martinez-Fernandez. 3. The usual instrument filed to obtain jurisdiction over an accused for a misdemeanor offense is a misdemeanor complaint. People v. Kalin, citing CPL 100.05, 100.104. It contains an accusatory part charging the designated offense and a factual part alleging facts of an evidentiary character supporting or tending to support the charges, CPL 100.15, see CPL 100.15, Kalin. Crucially, a misdemeanor complaint serves merely as the basis for commencement of a criminal action, permitting court arraignment and temporary control over the defendant's person where there is as yet no prima facie case, People v. Weinberg. However, it may not serve as the basis for prosecution unless the accused expressly waives the right to be prosecuted by a misdemeanor information, Kalin, citing CPL 100.104, 170.65, 1, 3. Such a waiver allows a defendant seeking expeditious resolution of a case to consent to be prosecuted on a misdemeanor complaint, thus relieving the people of their obligation under a misdemeanor information to proffer non-hearsay allegations establishing every element of each charge, see CPL 170.65, 3, People v. Casey. By waiving prosecution by information, a defendant declines the protection of, and the accusatory instrument must only satisfy the reasonable cause requirement, People v. Dumais. Under that more lenient standard, the factual part of a misdemeanor complaint must allege facts of an evidentiary character, CPL 100.15, 3, demonstrating reasonable cause to believe the defendant committed the crime charged, CPL 100.40, 4, b, People v. Dumas. Reasonable cause exists when information which appears reliable discloses facts or circumstances which are collectively of such weight and persuasiveness as to convince a person of ordinary intelligence, judgment and experience that it is reasonably likely that an offense was committed and that a particular person committed it, CPL 70.102. So long as those disclosed facts or circumstances give defendants notice sufficient to prepare a defense and are adequately detailed to prevent a defendant from being tried twice for the same offense, they should be given a fair and not overly restrictive or technical reading, People v. Konieczny, see People v. Sands. 4. The misdemeanor complaints here satisfy the reasonable cause standard. The complaints stated the time, date and location of the events, and otherwise provided defendants with enough information of how defendants committed the crime to put them on notice of the crime and to prevent defendants from facing double jeopardy on the same charges, Dumais. Defendants knew from the complaints what they were accused of doing and where, when, and how they allegedly did it. Based on the complaint's allegations, defendants could assess what defenses were available to them, such as contending that they never knew their licenses were suspended, that they were never served with a summons, or that the summonses didn't warn them that their licenses would be suspended if they failed to respond. Nevertheless, defendants contend that the complaints fail to provide reasonable cause because they did not specifically allege that defendants personally received the summonses. But reasonable inferences drawn from the sworn allegations in the complaints and defendants' certified driving records defeat that contention. As the People explain, an officer must deliver a traffic summons to the alleged violator after the occurrence of the alleged traffic infraction. Here, the numerous summonses issued to each defendant are sufficient to convince a person of ordinary intelligence, judgment, and experience that it is reasonably likely defendants received at least one of them. Additionally, defendants' consent to prosecution by misdemeanor complaint relieve the People of their obligation under a misdemeanor information to proffer non-hearsay allegations establishing every element of each charge, CPL 100.40, 1, c, CCPL 100.15, 3, 100.40, 4, b, 170.65, 3. Although that obligation known as the prima facie case requirement applies to an information, a misdemeanor complaint, in comparison, need only set forth facts that establish reasonable cause to believe that the defendant committed the charged offense, Dumais. Nor were the complaints deficient simply because they did not explain how the officers knew about suspension warnings appearing on traffic summonses or about those suspensions occurring automatically by computer within 4 weeks of a defendant's failure to answer those summonses. We do not require complaints to contain such formulaic recitation, Kalin, see People v. Aragon, Sands, Konieczny. Moreover, at this stage, the officer's statements about summonses appear reliable, CPL 70.102, inasmuch as the law tasks officers with delivering traffic summonses to alleged violators. Our cases analyzing the sufficiency of misdemeanor complaints alleging criminal possession of a gravity knife are instructive. In People v. Drayden, a defendant challenged the sufficiency of a misdemeanor complaint merely stating that the arresting officer had seen the defendant in possession of a gravity knife, in that, the officer recovered said gravity knife from defendant's person. People v. Sands, quoting brief and appendix for defendant appellant in Drayden. We determined that conclusory language failed to give any support or explanation whatsoever for the officer's belief, thus depriving the defendant of due notice of the charged crime and rendering the complaint jurisdictionally defective. Drayden. In contrast, in People v. Sands we rejected a defendant's contention that, to be jurisdictionally valid, the misdemeanor complaint should have alleged the arresting officer's training or experience in identifying gravity knives. We explained that the defendant misunderstood our decision in Drayden, inasmuch as the law does not mandate that an officer recite that he or she has training and experience in identifying gravity knives or expressly state the origin of his or her skills in that area. Instead, the principle enunciated in Drayden was that, when an allegation involves a conclusion drawn by a police officer that involves the exercise of professional skill or experience, some explanation concerning the basis for that conclusion must be evident from the accusatory instrument. Consequently, we held in Sands that the accusatory instrument sufficiently pleaded that the police officer exercised his expertise by simply testing the knife and determining that it opened and locked in the manner prescribed by the gravity knife statute. The same reasoning applies to these appeals. Both misdemeanor complaints pleaded sufficient facts to infer that the officers relied on their professional skill and experience to determine that defendants knew or had reason to know they were driving with suspended licenses, inasmuch as the complaints allege that traffic summonses have printed on them, "If you do not answer this ticket by mail within 15 days, your license will be suspended," and that the suspension occurs automatically, by computer, within 4 weeks of the defendant's failure to answer. Those averments in the misdemeanor complaints, in addition to the DMV abstracts, demonstrate the officer's non-conclusory basis for believing that defendants knew or had reason to know their licenses were suspended. Just as in Sands, no more was required because the officers established that they exercised their expertise through their averments about license suspension warnings on summonses and automatic suspensions. Those allegations, like the officer's allegations in Sands about operating the gravity knife and comparing it to the statute outlawing such knives, were sufficient evidence of a factual nature from which a person could reasonably infer defendants knew or had reason to know that their licenses were suspended. Vehicle and Traffic Law Section 511, 1a. The truth of the allegations is an issue for trial. It is not a basis for dismissing a complaint for facial insufficiency. See Dumay. Thus, the appellate term correctly determined that the complaints in these cases are facially sufficient. Finally, Martinez-Fernandez contends that the complaint's reckless driving charge was facially insufficient. Inasmuch as Martinez-Fernandez pleaded guilty to the facially sufficient charge of aggravated unlicensed operation of a vehicle in the third degree in satisfaction of the entire misdemeanor complaint, we need not reach his challenge to the reckless driving charge, see People v. Pelchant, nor his claim that the traffic infraction count should be dismissed. Accordingly, in each case, the order of the appellate term should be affirmed. People v. Willis, order affirmed. Opinion by Judge Troutman. Chief Judge Wilson and Judges Rivera, Garcia, Singas, Canataro and Halligan concur. People v. Edward Martinez-Fernandez, order affirmed. Opinion by Judge Troutman. Chief Judge Wilson and Judges Rivera, Garcia, Singas, Canataro and Halligan concur. Decided March 13, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law